And here we go. This is the latest filing from me and written by my lawyer, Ron Coleman, representing me, to Alyssa Mercante and her team of 3 lawyers to the United States District Court, Eastern District of New York. And this is the reply memorandum of law in support of defendant's motion to dismiss the second amended complaint. Try to keep up because there's been a lot of back and forth and amended complaints and updates, and we want to add on this and this other thing. Defendant respectfully submit this reply brief in further support of his motion to dismiss the complaint pursuant to Fed R Civ blah blah blah. Plaintiff has failed to meet the burden of establishing subject matter jurisdiction and has not satisfied the pleading requirements under FRCP 8. Now, a lot of this is going to be lawyer jibber jabber, whatever, back and forth. But I will say I already read through this before once, and it gets incredible, especially towards the end. Some research that I've done and had people also confirm with me that the history of this judge is, at least historically, with their decisions and what they've dismissed 2 harassment cases previously. And I believe one of those that was dismissed was because the plaintiff failed to meet the burden of establishing a subject, AKA, we don't even know what she's suing me for. Like, they keep saying, oh, harassment, that's what she's suing me for. It's like, right, but what exactly did I do that qualifies as harassment? And what we are saying is nothing that they are stating actually qualifies as harassment. So if this does get even heard, like even if the judge is like, you know what, based off of jurisdiction, I'm going to hear this out. I'm willing to hear it out. And I'm going to make a decision on it. And they could theoretically say, yeah, I'll hear it. And I'm going to toss it out because you didn't actually have a subject matter at hand here. So I'm just, there's a lot of different directions they could go with this. But again, I keep going back to, in my personal opinion, and many others, of course, there's nothing that I did that is qualified as harassment. And that's the ironic part of the lawsuit being sent towards my way, being based around harassment. In his moving brief, the defendant cited Dykstra versus St. Martin's Press and Greensburg, Schweitzer, for the proposition that on a motion under Fed R Civ for failure to state a claim, courts employing New York law will consider documentary evidence to establish context relevant to affirmative defenses or for context. Plaintiff mistakenly construes this as an argument that federal courts should apply a heightened pleading standard in defamation cases because New York's anti-SLAPP law, a position she correctly observed the Second Circuit has rejected. It is not, however, a position that defendant has asked the court to adopt. Rather, defendant cited these cases in support of a legal axiom. The substantive law of defamation requires any court to consider any statement alleged to be defamatory in the proper context. Remember that important thing, Alyssa? The thing you keep leaving out? Context, because context really matters. The context provided by defendant because the material is not contained within the 4 corners of the pleadings. And again, banger response here by Ron. He sent this to me before he submitted it to the court. And I was just like, I was blown away when I read this last week. The court cannot determine if the alleged defamatory posts by plaintiff could be defamatory as a matter of law without considering those posts in their complete social media context. AKA, they are posting one thing that she said and one thing that I said, and they're saying what I said is harassment to her without the greater context of everything else. Plaintiff, understandably, would prefer that the court ignore the context of the defendant's comments. Consideration of the screenshots included in defendant's motion to dismiss, they assert, would constitute consideration of material extrinsic to the pleadings, which is typically prohibited on a 12b6 motion. But this argument would gut the entire concept of considering a statement in its appropriate context to ascertain whether it is defamatory as a matter of law, as defamation law requires. Plaintiff asserting defamation are, to put it mildly, unlikely to include the context that would tend to lessen the defamatory effect of a statement in their pleadings. AKA, if she, I don't know, doesn't cut out what I say leading up to what she posts saying, oh, I said this, it really makes her look bad because it weakens her stance saying that I'm harassing her, given the full context of what I say. As the Southern District explained in this case here, not only should a court consider such materials, especially in the context of Twitter, i.e. X, but a defendant is remiss for failing to bring them to the court's attention. And then he quotes what that whole case talked about. Indeed, consideration of tweets now known as X posts that provide appropriate context in defamation cases is standard operating practice in this circuit. A leading federal case in the circuit supporting this is this case here, cited here, which explained as follows in analyzing defamation claim. And they talk about, I actually want to read this because this talks about what they've decided before. First, the court will take judicial notice of Defendant's Exhibit 3, which, in addition to the tweet at issue here, displays two other tweets that defendant posted on July 27, 2018, approximately 20 minutes before the tweet, all of which are related to the same topic. These two other tweets are part of a parcel of defendant's interjection into the conversation thread between the two people. Therefore, to only look at the tweet rather than all three tweets posted during a 20-minute span would not provide the necessary proper context for understanding defendant's statements that morning. Which, yeah, these are, by the way, as much as people might hate like the judicial system and court, I do feel like they try to be fair and they try to be reasonable to be like, okay, this person's claiming harassment. We need to understand fully what they're claiming and where that's coming from. Because what we're dealing with right now, in my humble opinion, is someone that is disingenuous and leaving out context. Alyssa lie by omission Mercante, to which I have dubbed her, because so often does she lie by omission in her reporting, in her journalism, in her YouTube videos, how she cuts out context constantly on tweets, on screenshots, cutting out who said what. It is an epidemic in her brain that she seems to not be able to overcome. And she is continuing that in her lawsuit with me. It says, see also this. Courts considering tort actions arising from Twitter posts regularly rely on statements in the thread, blah, 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 all this fun stuff. These analyses all emphasize the importance of applying the context rule in a real-time social media setting, but they are ultimately all applying a well-established legal principle. See this case here, which again, Ron crushed it here, citing every single case that applies directly to why this is ridiculous. Social media screenshots that include defendants' allegedly defamatory statements, as well as their immediate context, are integral to the allegations of the complaint. He continues talking about a lot of the things that are connected to the context, which you can pause and read through that, but it's basically more of the same. Then he goes into the court cannot determine if plaintiff is libel proof as a matter of law without considering her own posts in which she describes herself in a degrading fashion, such that her reputation will not sustain an action for defamation. Now, for those of you that follow me on social media, before I even go further, I posted something yesterday in regards to Alyssa Mercante and what her latest rebuttal to our case was. Defendant likes to call her sometimes Mercante, emphasis added, to which I screenshotted a arrow, that's a red arrow, pointing to a see you next Tuesday clip in plaintiff's hair. Your Honor, we are dealing with a psychopath that is taking things out of context that clearly embraces being these things, except when it doesn't fit her narrative and she wants to sue people for it. That is insane to me. That is absolutely insane. Additionally, as plaintiff argued in his moving brief, this case teaches that a court can and should take judicial notice of matters relating to reputation that are not in dispute in order to determine if the plaintiff is even capable of maintaining defamation action as a matter of law. Plaintiff ignores this argument, and this understandably, yet it is merely one example of a legal doctrine well established in this circuit. And it quotes it, this libel-proof defense has been held suitable in cases where the truth or undisputed evidence of the plaintiff's past had already severely damaged the plaintiff's reputation. Now, remember, this is coming from a girl that completely embraces being a slut. Was that casting couch from Giant Bomb saying that she's smart, slutty? That's somebody that embraces being a slut. When I hear her say that, like, okay, she doesn't seem to be offended calling herself that. Apparently, she just takes offense when other people call her that, but only if it's people she doesn't like, Your Honor. Because if it's someone she does like or they align ideologically, it's perfectly fine.
If it was consensual and you didn't hate the Jews, I'd fuck the shit out of you. I would.
Weird. I would never say something like that to Alyssa. That's far more egregious than anything I have ever said. But yet I'm the one being sued here, which is crazy. This is such a case. Whether or not plaintiff is a whore or a sex worker is not at issue here. What is at issue is that she has repeatedly described herself that way, regarding which there are no grounds for dispute, which this is what destroys her case right here. She cannot fight back against this. She has no leg to stand on. The court should decline plaintiff's attempt to wrench defendants' online comments from their context, including plaintiff's own debased and degrading descriptions of herself, her conduct, and her moral views, because the law requires that context in order to evaluate. This is great. So what Ron is saying is, hey, they're welcome to say that I said things about her, but if they're going to do that, they also need to provide exactly what she said about herself as well in context of what I have said. And they have not done that at all. They have just provided what I have said and nothing, pretending like she's just this like beautiful butterfly that would not harm a fly. She's just a beautiful, pretty flower out there in the world that's getting trampled by evil, bigoted, misogynistic men. And I am the leader of the crew of all these men, and it's just horrible. It's like, no, that's not. They're trying to paint that picture, but that's not what's happening. Whether Mr. Tarzier's comments would be construed as defamatory in the social media context, and whether it is even possible to defame this plaintiff who has crafted an online reputation as a militantly libertine feminist who embraces an identity, whether real or for show, of whore and sex worker, in quotes, as a whore or a sex worker. You know Ron had some fun writing this. Plaintiff has failed to demonstrate that the Second Amendment complaint plausibly alleges facts, which, if true, would establish this court's personal jurisdiction over defendant. Basically, he's saying they tried to demonstrate why New York should have jurisdiction. And Ron's like, yeah, they tried to, and no, they didn't. And here's why, Judge. Plaintiff argues in her opposition that this court has jurisdiction pursuant to this and this. As demonstrated below, neither provision of New York's long-arm statute applies here. And again, this is very big. I personally think that this case will be thrown out based off of jurisdiction. I could be wrong, but that's my sentiment, my feeling on it. If it does not get thrown out on jurisdiction alone, and the judge is like, yeah, I'll hear it, then see point A that we were just reading here with all these things where it's like, yeah, if you are going to hear this, Judge, this is a ridiculous case, even if you do hear it, but you shouldn't hear it because it doesn't even fit the jurisdiction. To establish jurisdiction, a plaintiff must allege that the defendant has transacted business in New York, and 2, claim asserted arises from the business activity. New York courts do not interpret transaction business to include mere defamatory utterances sent into the state. Although this does not include defamatory from its coverage, New York courts construe transacts any business within the state more narrowly in defamation cases than they do in the context of other sorts of litigation. Even if the SAC did adequately plead that the defendant transacted business in New York, moreover, plaintiff's opposition makes it clear, albeit by omission, that she has not alleged that her claims arise out of the defendant's New York activity. That's a mic drop right there. Like he just straight up said, like, okay, so they tried to get this jurisdiction. Like, yes, we've established that he's here in New York. Now let's make up a whole bunch of stuff about why it's harassment, even though none of it has to do with me being jurisdiction in New York, notwithstanding activities of any of his friends and associates. Absent such a showing, personal jurisdiction cannot be claimed over non-domiciliary defendants under Stroud versus Tyson Foods. Plaintiff also misconstrues the meaning of targeted. Ooh, I actually want to read this because she loves to say targeted harassment or hate campaigns. Defendants' online activities consist, this is from a different case here, and as such, do not provide a basis of jurisdiction. The sole connection between plaintiff's cause of action in New York, the fact the plaintiff, the subject defendant posting, is a resident of New York, is not sufficient to support a finding of jurisdiction. Beyond the internet activity already referenced, plaintiff has submitted no further evidence to connect the defendant to New York. Furthermore, defendant attests that no web page of any websites or public message postings have ever been directed at the forum state of New York. Anything I advertise, publish, or state as a matter of free speech is intended to be read by the entire worldwide internet audience, not just New York, by the way, and is not directed at any specific forum. As there is nothing in the record that suggests the defendant has purposefully availed herself of the benefits and protections of the laws in New York, there is no jurisdiction under Section 302. I'm talking about more of that here. Here, B, the court lacks jurisdiction under CPLR 302. Plaintiff also relies on this, however, which by its terms do not apply to defamation actions. In doing so, plaintiff once again disregards the rule addressed at length in defendant's moving brief. I love how he wrote that there, basically telling the judge, like, hey, yeah, we already talked about this. And when they replied, they kind of ignored that. And that was kind of like a really big point where they need to address that, and they didn't. The courts sitting in New York are instructed to decline jurisdiction over claims that attempt to avoid the requirements of New York's long-arm statute by merely restating a defamation claim under a different name, which is what they're doing here, allegedly. Plaintiff relies on a non-defamation case, and this one here, where a campaign of attacks at a New York company plus interactive websites suffice to establish long-arm jurisdiction. This reliance is misplaced. First, plaintiffs have failed to allege facts establishing that Mr. Tarzier's YouTube channel is, in fact, an interactive website. It stretches the meaning of transacting business to subject defendants to personal jurisdiction in any state merely for operating a website. However, commercial in nature, that is capable of reaching customers in that state without some evidence or allegation that commercial activity in that state actually occurred. Here, there is none, other than, at best, a mere guess, which, oh, by the way, their accusations at me are how many 60-plus pages or so of guessing, many allegations and guesses. What is it? Upon fact or belief, what? Understanding or belief or something they say, where it's like, no, you're guessing. That's another word for guessing. See, also, this one here, passive websites, which merely make information available to users, have been analogized to an advertisement, nationally available magazine. Yeah, exactly. Nothing in the SAC plausibly alleges, nor can the entity of its narrative, which insists that Mr. Tarzier sought to maximize his viewership as opposed to his viewership in New York alone, which, yeah, no, I've never, that's, why would I seek to increase my viewership in a certain state? That makes no sense. Like, unless I'm like, I don't know, like if I'm like a Boston Celtics basketball channel and I live in California, I might be like, oh, I really need Massachusetts to watch me and stuff. And that might be a case where talking about like generic video games, like, no, what? That any of his alleged conduct was meant to have an effect on New York audience. This court does not have personal jurisdiction over Mr. Tarsier. Number 3, we're getting towards the end here, and stand by, guys, because this gets really good. Plaintiff has failed to demonstrate that the Second Amendment complaint states a claim for any cause of action sounding in defamation. Putting aside, for the sake of this motion, the issue of jurisdiction, plaintiff's submission only reinforces the preposterous nature of this defamation lawsuit, which, again, the judge, like I've told you a few times, but they keep reiterating and missing this, is all it is. Here, while plaintiff asserts she pleads different damages because certain of her business relationships allegedly suffered, the fact remains that any, and this is in quotes, any economic damages would derive from the defamatory statements. And as the plaintiff's authority confirms, the key question is whether the reality and essence of the action can be considered defamatory in nature, which the amended complaint clearly is. In an earlier iteration of the Delgado case, damn, Ron's diving deep here. Like, he didn't need to go this far. I'm impressed. Essentially adopted by the court per the last citation, the Southern District described with balance and perspective the present state of play with respect to legal claims arising from a sort of public forum never envisioned by the chancellors who shaped the ancient laws of defamation. And he cites all the stuff there. You feel free to pause it and read through. He cites Barstool Sports and Rappaport. That's a good one. As the Delgado court acknowledged, notwithstanding the Wild West-like quality of the internet discourse, there are all the same appropriate times and places for the law to intervene in aid of those whose reputations, livelihoods, or family lives are harmed by false and defamatory accusations. Which, oh, by the way, and I'm not trying at this point to claim damages, but I sure as shit would be if I didn't have the community's support behind me. But ironically, because of the community's support, I don't know if I can really claim damages. Maybe. I'm no lawyer. But this whole ordeal, and I know Alyssa's probably ready to clip this, but this whole ordeal has shown that the community has supported me in fighting back against this because they feel like this is something that is unjust. This tawdy contest is not one of those times. This case is an expensive, here we go. And this is why I love Ron. This case is an expensive, petty slap fight over social media shit posting from opposing camps in the 21st century's endless culture wars. Wasteful mudslinging by a woman who has immersed herself in mud as a fashion statement. I'm telling you, it gets so good. If stochastic terrorism were anything besides a trope deployed to describe perfectly legal things certain activists do not like, it would look very much like this lawsuit. Oh my God. God damn. When Ron sent this to me initially, I highlighted that part to him and I was like, bro, you cooked here. Like, holy shit. And Ron, ever the professional, just like, well, thank you. Enough public and communal time has been wasted on this dispute, which, by the way, I can genuinely respect the lawyer that wants this shit over with. Ron is not trying to drag this out. Ron is trying to get this over with as fast as possible because this is a nuisance. It's getting extremely, stupidly expensive before we even get to a court, before they even hear anything. So he is proactively telling the judge, like, Judge, this is stupid. It's getting really expensive. And they're just slinging mud at each other. Like, tell them to knock it off if you want, but this is not a harassment case. Like, what the hell is even happening here? Enough public and communal time has been wasted on this dispute over the notional honor of a lady who has built a persona around dishonoring herself and the modern women in whose name she claims to speak. Careful, Ron. You're going to get a lawsuit harassment thrown at you next. Alyssa's like, and I am now labeling Ron in my harassment suit. We're going to need another addendum because we also want to sue Smash JT's lawyer. Because he said mean things in his response to me. It should not occupy the good offices of the federal court in New York. And the court should send it back to the no man's land of social media where it belongs. Thank you. Holy shit. Conclusion. For all the foregoing reasons, the complaint against Jeff Tarzia should be dismissed with prejudice, and the defendant should be awarded fees and costs pursuant to New York's SLAPP laws. Signed by Ron D. Coleman. Shout out to the absolute boss, Ron. Appreciate you, bro. Holy shit. What a banger. What a banger. Like I told you guys, when this came through, I was like, damn. Court's going to read this and like, damn. Orange Mushroom says, claim your damages. Well, that's for the court to decide if they are willing to hear out the SLAPP this shit here, potentially. I've said this in DMs to many people I've spoken to about this. While I am getting, of course, animated here, and I love the direction this is going, I'm doing my best to stay grounded because I don't want to expect an outcome. Because again, you never know what they're going to decide, and it could be the worst thing in the world for me and my family. And I am trying my best to prepare for that. But at the same time, the realist in me looks at this and just rolls my eyes, being like, what even is this? Like, I couldn't imagine on any court in the United States of America where they would hear this and be like, yeah, he's the bad guy and he owes you all this. It's like, for what? For what? It's crazy to me. But you never know. You never know. So I'm trying my best not to pull a Carl Jobs and assume a victory here, but it's really hard. It's really hard. I'm trying my best though. But with that all being said, I did talk to Ron today about this, and I asked him the obvious follow-up of, I know people are going to be wondering, what's the next step? What's the time frame? What, all the what? And he said, don't expect a response from the court for at least a month. At least a month, I believe was what he told me. It could be upwards of a year. These are Ron's words. He said anywhere from a month to a year. Ideally, we'd like it to be closer to the month, but you never know how slow a court operates and processes information and what they decide and what's going on. It depends on so many things. We could find out tomorrow. We might not find out for a year. Like, who knows? But it is now in the court's hand. Judge Margot Brody is the Honorable Judge Margot Brody is in charge of deciding what to do with this case right now. And I'm hopeful it gets dismissed with prejudice and the defendant, which is me, gets awarded with fees and costs pursuant, which would be, at this point, we're approaching somewhere around the ballpark of almost $50,000. So if the court were to judge that and have that sent back to me, that would definitely be something. Wouldn't that be something? I hope Alyssa is able to do her own fundraiser to assist herself if that is what ends up happening. We will see what happens, but I just want to keep you guys updated. And I don't expect to have an update for you for at least a month, but I'll keep you posted, as you know. As soon as I hear anything, I am an open box of intel. I have no secrets, nothing to hide. And I'm more than willing to just say what's happening, because I know that I am allowed free speech. I know that I've done nothing wrong here. It's just a matter of making sure that we get that across to the court. So we'll leave that there.